Good afternoon, everyone. I hope everyone is doing well and staying healthy during this challenging time with COVID-19. Today's webinar is geared toward nursing facility administrators and business office managers and staff. If your business office folks are not already registered to jump on the webinar today, please feel free to go get them now while I'm going over some housekeeping items, and they'll be ready to hear the presentation. Also, please feel free to type in your questions into the questions pane on the right hand of your screen. Our presenters will be happy to address your questions throughout the presentation. Thank you for joining PHCA for today's webinar, COVID-19, the Courts and Medicaid Eligibility, Navigating and Overcoming the Challenges. I'm Wendy Johnson with the Pennsylvania Healthcare Association. Before we begin, I have a few housekeeping items to cover. PHCA offers monthly webinars to members to receive updates from department staff on regulations, learn from industry experts on current trends and practices, and to gain a better understanding of practical application tools to equip you so that you may continue to provide the highest level of quality care possible. This webinar is being recorded and will be made available on the PHCA website. The webinar has been approved for one continuing education credit for PHCA members, and during the COVID-19 crisis, we are offering the credits to potential members as well. Credits will be uploaded to NAB within the next 2 weeks for those who have provided us with your unique NAB number. I will be sending a link to a quick survey. Your feedback is important to us and to our speakers, so please take a moment to complete the survey. All attendees will be in listen-only mode. However, throughout the presentation, please feel free to submit your questions using the questions pane on the right hand of your screen, and our presenters will address them throughout the presentation. Today's webinar is being presented by John Kennedy, President and CEO, and Rodney Myer, Managing Shareholder, both long-term care facility attorneys with Kennedy PC Law Offices. This webinar is geared toward community administrators and business office managers and staff. The COVID-19 pandemic has caused changes in timing and procedures for Medicaid eligibility, guardianships, and the courts in general. John and Rodney will highlight the specific changes and explain strategies to efficiently achieve your community's goals in this extraordinary time. They will discuss the changes to the Medicaid application, appeal, and redetermination processes caused by COVID-19 and provide tips to navigate them. Plus, they will discuss the availability of emergency guardianships during this time. Finally, they will review the court closings and how long they will last, the types of hearings that continue during the closings, the effects on your communities and residents, and methods to mitigate delay and other negative consequences. I'll now turn the webinar over to John and Rodney.
Thanks, Wendy. Hello, everyone, and thanks for taking time out of your busy schedules to sit in on the webinar. Before we get into the nitty-gritty of the details on the webinar, I want to just go over 2 points before proceeding. And the first point is I just want to thank everyone all the participants and all your staff and the administrators and all the healthcare providers for the work that they've done throughout this crisis. You guys are the frontline workers at the epicenter of the problem, the COVID-19. So I want to thank you. We appreciate what you're doing. I think the long-term care industry has been underappreciated for quite some time, and we're hoping that changes. The other piece I want to bring up, and I spoke with Zach at PHCA before doing so, was this is primarily focused on financial matters that are impacting the facilities. So one financial matter impacting the facilities along the theme of being underappreciated is being underfunded. So there are bills in the process, the legislative process, that would finally allocate necessary resources to the long-term care industry. I'll give you a quick update on both of those, then we'll get into the material. So Senate Bill 1122 passed the Senate, and it's waiting for a vote in the Pennsylvania House of Representatives. That'll put about $507 million into the long-term care industry on the whole, and $290 million worth of direct payments to skilled nursing facility providers. That vote should occur within the next few days. If you like to encourage your representative to move along that vote, feel free to do so. In the House, they proposed a bill for around $400 million to go through eventually the long-term care industry, but a healthcare collaborative being set up in the interim to manage that money. I think that's going to be a longer process, and I'm not sure exactly where that stands. But Senate Bill 1122, with $200 million allocated for direct payments to Pennsylvania nursing homes, would be a good thing. So that is good news, and hopefully that'll happen sooner rather than later. And then with regards to Medicaid eligibility and the courts and what have you, more good news is, although things may be a little bit slower, there hasn't been any real catastrophic events to, really slow down the whole Medicaid eligibility system to the point where it is stopped, and there's no approvals coming, and there's no funding coming in, and what have you. So, Rod, if you could switch to the summary page, we'll give you an overview of what we're going to talk about. So I'm going to go on the Medicaid side of things, then we'll turn it over to Rodney to talk about courts, orphans court issues, and what have you. So from the big picture here, here's what we're going to be talking about. What is the story with MA redeterminations? And then I reached out to a lot of our clients to talk to them about what are they saying with the applications? Are there any problems? Obviously, attorneys are involved in the applications, and attorneys are involved in many of the appeals that are going on. It's not cost effective in the majority of circumstances. So I reached out, and we have some information from our clients, and I appreciate that. So we'll talk about applications. We'll talk about what's the situation with the MA pendings. Of course, appeal of the MA pendings, the denials, and we'll talk about BHA hearings. I'll mention the level of care denials. We'll talk about resident stimulus payments, and then a little bit on other medical expenses, which really isn't a COVID-related issue. It's just a general issue. So, Rod, can we go to the next slide there? Yeah, I don't have the ability to control that from my computer for some reason. So Rod's going to talk about the effects on the PA courts, COVID. He'll talk about what happened initially, what closures occurred initially, how that impacted everything that we are doing on your behalf, and then focusing, on that as it relates to emergency guardianships and then standard guardianships. And, with a lot of counties going to yellow, what are the changes and what are we looking at over the summer? So that's the overall process. Okay, so MA redeterminations. This is when somebody's in your facility, they need to renew annually. There's requests for information sent out to the recipient. They're supposed to respond to that. And if everything remains the same, they're still on Medicaid. So obviously, because of the COVID crisis, the state changed those policies. And so basically, for renewals requested and or due on or after March 18th, 2020, which was the date of Wolf's court order, the CAOs will not close any MA long-term care case other than for the following reasons. Individual no longer resides in Pennsylvania. An individual requests their benefits be closed. An individual has passed away. And then they just revised this in late May to add the last piece, which is a lawful residing non-citizen turns 21 and pregnant women at the end of the postpartum period. So very limited circumstances where anybody's case is going to be denied or terminated or not renewed. Next slide there, Rob. Thanks. But along those lines, our clients are still getting requests for documents in support of the annual renewal. So what are you supposed to do with those? So I reached out to counsel for Department of Human Services for Pennsylvania and got some further clarification on that. So if you can provide the requested information to the county assistance office, go ahead and do so. So if you have the documentation, or the resident has the documentation, or the family is cooperative and can get it, then so be it. Then submit it. If you can't, and then it's due to the COVID-19 crisis, you need to tell the CAO that I can't get the renewal information, and here are the steps that we could take, and here are the steps. And here's why we can't take any further steps because of COVID. So, and I think I have one more slide on that, Rod. Okay. So basically, if you can, provide the information. If you can't, tell them you can't. Tell them why. Then the CAO should maintain the client's long-term care eligibility until the month the emergency ends. So we'll see when that emergency ends. I guess that's when everybody's green. Remains to be seen. Upshot of this is the CAO should not be discontinuing benefits at this point, period. And then throughout the hour here, we'll be giving you some recommendations. Some of them are pretty common sense, but what's going on now, we'll give you recommendations, and then we'll do a summary of the recommendations at the end. So, recommendation for this, respond to the request if possible. Otherwise, apprise the CAO why you cannot respond due to the COVID crisis. So you'll keep the flow of revenue. So applications, I haven't heard too many problems with the ability to submit applications and to start the whole process. So people are either doing it on Compass, online, and I should take a step back. It's going to vary county by county, CAO by CAO, what processes they're following. But any combination of these I've heard have been effective and hasn't been very problematic. So either fax, mail, email, online. You can't physically go to the CAOs anymore. So haven't heard too many problems about getting applications submitted. So that's good. So what is a recommendation with the applications? Well, what has not changed under COVID is the fact that you need to submit an application and that retroactivity period from the application is still the same. So if you submit it, it goes 90 days retroactive to the first day of that month. So recommendation, facilities should still file the applications if the resident and family members cannot or will not. Okay. Thanks. So this is new, brand new from the COVID, due to the COVID emergency. So an MA bulletin came out, and the CAOs are operating under a different standard now when they're processing applications. And I quoted the standard, and it's in italics. And the bulletin states, flexibilities in timeliness and verification standards are being utilized by the CAO. So I think in the short term and the long run, that will be helpful to all providers and able to get their applications processed, notwithstanding the problems due to COVID. And I think we need to remember that standard. It's a flexibility standard, and I think it'll be helpful moving forward. So the recommendation there is to utilize this standard if you are doing your own hearing or you're in discussions with the CAO with regards to trying to get somebody eligible. Here's the steps that we've taken, and I'll get a little bit more into that in a minute. But that's a good new thing to hone in on, that flexibility standard. So MA pending cases. I've called people, did some informal questionnaires and polling and what have you. And some facilities are reporting delays in processing the applications. Other facilities say some of the applications are being processed more quickly. I think generally there's probably just a whole slowdown in the process. The ones that are being processed more quickly, what I'm hearing is that if somebody has all their documentation in order and it's submitted, because the CAOs are either working at home or online, and they don't have a lot of other people coming into their offices disturbing them, they're focused, they're getting it done, and they're getting those processed more quickly. The delay could be for any number of situations. One, it could just be the CAO's working arrangements. It may be less efficient. People like to work from home, but I think can be less efficient. And also, this flexibility standard used to assist providers, it can actually kind of be a double-edged sword. I think in the long run, in the short run, being flexible with timelines is going to be more helpful to providers than harmful. Although you want your applications processed quickly, you don't want them denied because you can't get documentation due to COVID. So it could be that the CAOs are implementing this flexibility standard. I know they're extending timelines for people to get approvals and what have you. So I'm thinking.
John, can I jump in with some questions?
Yeah, sure.
Is it a good question? Okay.
Yeah.
We have two questions so far. The first one, actually maybe more of a comment. Issues have been seen that the requests for documents are not being received. Centers check Compass and see that the MA application has been denied and has not received the denial.
Well, I have not heard that. And if it's in Compass, I guess what I would do there is recommend you following up with the CAOs and saying, I don't have a request for verifications, and I never received a copy of the denial. You know, from a legal standpoint, if you don't receive a copy of a denial, then the clock does not start ticking along those lines anyway. So that's the first I've heard of that problem. And I will note it, and I will try to follow up and see what problems maybe they're having from Encompass and getting the physical documentation out to the providers. Another thing
we have another.
Go ahead.
And let me read this one. It could be similar. Regarding MA renewals, no terminations other than what was listed. What is the effective date this took effect so that we can identify cases closed in error?
Okay, so I spoke with DHS counsel, and they said it was for any renewals that would be that were requested after March 18th, 2020. And I said, well, requested after March 18th, 2020 may not seem to make sense. It should be that we're due on or after March 18th, 2020, because the COVID issues occurred when it's due. So the renewal isn't sent out and then it's due the same day. So I would say anything that was due to be renewed on or after March 18th, 2020 would fall under this COVID, and I would definitely address that and get that corrected.
Great. Thanks, John. That's all the questions we have right now. Again, anyone who has questions, please type them in your questions pane, and we'll address them throughout the presentation.
Okay. Okay, so we have reports of delays. Once people are actually getting a verbal confirmation from the caseworker that the person has been approved, actually getting the PA 162 in their hands so they can start billing has been a problem. And I know some of the providers have been working with the CAO supervisors who may be on site more often than the caseworkers. And that was just a recommendation to try to work with the supervisors. Maybe they can email you the PA 162 so you can start billing and moving forward. But that's just sort of another wrinkle. It sounds like we're having a documentation, getting them out the door from the CAOs in general.
Okay, John, we have another question. As we're changing slides here, it might be a good time to get this one in. If you had a stipulation from a telephone hearing, the CAO agreed to send notification by May 6th as approved or denied based on the information given, and the caseworker was contacted by email and phone with no response, should I follow up with the judge or still need to wait for the CAO?
Okay, so it sounds to me as if you had a stip, the CAO was going to issue a PA 162 one way or the other by May 6th, and they haven't done so, and it's May 21st. So generally, if you look in the BHA order, you have 30 days from the last day, and action is supposed to be taken to file a notification of dispute. So, we always track that at our office. If we don't have the documents, if we don't have the PA 162 from the county assistance office, it may be a good idea to file that notification of dispute. And you have 30 days from May 6th in order to do that. That sort of preserves your right. Quite frankly, they still have an ongoing obligation to issue that PA 162, and with everything going on, it's probably can anticipate some sort of delays. but the notification of dispute will get it back in front of the judge. It'll get it back in front of the Bureau of Hearings and Appeals. And you can do it any time now, as soon as they didn't file it in a timely manner. But you're working with these county assistance offices every day. So, you tried to reach out, you tried to call them, you tried to email them. Those are the steps I would take before, filing a notification of dispute. But that'll get it in front of the judge. Yeah, Laura, let's go back to that. Okay, so here's another. So we have the big changes, I think, are the flexibility standard. Here's the next big change that could be helpful. So your appeal deadline from a denial on a PA 162, it was 30 days, and during the emergency period, it's 90 days. Okay, so that's out there. And so my recommendation for that is because you folks are generally trying to get these things processed more quickly rather than not, so you can get revenue flow into the facility. So I like the 90 days as a fail-safe, but I would say consider filing the appeal within the 30-day time frame or less just to get the ball rolling, if it works out. There could be a number of different things to analyze there as to whether it's appropriate or not, but I like the 90 days, but I would recommend 30.
John, I have another question here.
Okay.
If there is a delay in getting the 162 and it takes longer than 60 days to get the provider office and we need to submit to 180-day unit, is there an issue with 180-day processing those claims?
I haven't heard any problems with 180-day claims processing issues yet. I mean, it should be the date. They say it's the date of the PA 162, but if the issue is that it's dated prior to and you receive it later, just document when it's received. I can't imagine that would be an issue. You get to PA 162, then you have 60 days to go through the exception request process. For the older claims, obviously.
Okay. What date should the time appeal change from 30 days to 90 days?
The MA bulletin came out on that in March. I want to say March 22nd, somewhere around there. So I would think that would be the time frame. But I would also say, it's not going to hurt to file an appeal. It's not illegal to file an appeal at any given time. So if you think you may or may not be in with that time range, it's not going to hurt anything to try to file an appeal and to get the issue in play. And of course, if it's too late, you file another application and you get the 90 days back in the retro and start that clock running again. Okay, so moving into the administrative appeal, we're continuing with the administrative appeal. Verifications can be difficult to get for a myriad of reasons. Bank slow, no response, inability of family members to meet with the residents or assist in the process. So with the flexibility standard and the 90 days, this is the third biggest thing I think is very important to understand and to take away from today. Make all of these attempts to obtain the verification and document those steps. Because, again, there's flexibility in the verifications and the time standpoint. There's also legal arguments to be made and regulatory arguments to be made that if you've made all these attempts and you can't get the documentation, you can't get the verifications, arguably the person can still be eligible for Medicaid. So, Rod, why don't you flip to that next slide and we'll, okay, that's good too. So I'll get to the legal arguments in a minute. So you want to be, and some of our clients are saying, operating as business as usual. Even though they feel that they may not be able to get, or we feel we may not be able to get subpoenas or responses from banks or what have you, we are proceeding as if we are trying, as if it is normal. We're trying to get the documentation, we're trying to get the subpoenas going, we're trying to correspond with the banks, we're trying to get in touch with family members, resident communications, all of those things. And another thing, asset searches might be helpful from an evidentiary standpoint. If you can't get any documentation, but you can show an asset search that the person maybe doesn't have significant real estate or something like that. So those are attempts that everybody makes. Our office makes, you guys are making them. Okay, so make those attempts, document those attempts as if it's business as usual. Don't say, I'm not going to do it because I'm not going to get any response. Move forward. So, importance of that, again, the new CAO flexibility standard. If you argue I've made all these attempts and I can't get it, is that a flexibility standard? Perhaps. Common law doctrine of impossibility of performance. There's case law about that has to do with, meeting terms of a contract, which could be the terms of a STIP. I don't want to get into the minutia of all the legalese on that, but that is something that we have briefed and have had success on even before COVID, but I think we'll have more success with it even under COVID because you can't get the verifications because of the need. So then there's 2 state regulations too that will also be helpful trying to obtain these regulations but not able to do so. So one of the regs say in certain circumstances it may be impossible to secure substantiation. They use that instead of verification. If so, the CAO will make a reasonable decision based on certain factors in the regulations. Another reg says an applicant may not be denied for lack of verifications if he or she has cooperated in the verification attempt. So, generally the cooperating party, when we're involved, is the facility's been trying to do things and we're trying to do things. So it's really important to attempt to get these documents and to be able to document your attempts. Okay.
John, we have quite a few questions. Do you want to take those now or wait? Okay.
Sure.
First one is, we had a resident closed due to excess resources from the sale of a home. Should she have been closed during this time?
That's a great question. I saw one of those come across our desks collectively here as well, and I think that's different. You've got somebody that was maintained, and then they were seeking a renewal. That MA bulletin relates to renewals versus someone that had come into a lot of money, whether it's sale of a house or inheritance or what have you. So I do think that excess resources is different than failure to provide documentations for a renewal.
Okay, here's another one. I had sent in a 180-day claims in March, received certified postcard back that they received it. It was still not in promise by the end of April. I emailed Promise and was told with them working from home that they should be sending the claims and documents to them by email. You may want to announce this today for others to be notified.
Okay, so the advice is to, instead of you're mailing it to 180-day exception request, email it into them. Is that RA? Should we give everybody, do you have the email address? If you do, whoever is asking the question, feel free to type it on there and we'll relay that to the group.
Awesome. All right, next one. With the stimulus payments to the residents, how is that money to be spent since it is exempt? Okay,
so anytime, so the Fed said that stimulus payments are not a resource, and then Pennsylvania said the federal unemployment comp payments or what have you, they're not income. So they're both exempt. So how they spend it, it's not going to go as patient pay. It's not going to go to reduce the payments that are due from the state and or the CHCs. So I guess they could spend it however they want. But I know it's not going to have a negative impact on Medicaid.
All right, next one. Is it necessary to get something in writing to protect us in the event we are unable to secure requested verifications discussed at the appeal hearing? Is there specific wording you recommend we ask to have added?
Not sure exactly how to answer that. I mean, if you're looking for a response from somebody saying they can't get you the verifications because of the situation, and they're actually responding to you that they can't get the verifications, I just think any documentation that's going to show attempts were made and they were not successful. Any combination along those lines should help carry the day.
Okay, a couple more questions coming in. This is great. Keep the questions coming. This is good stuff. Can facilities ask residents to make payment from their stimulus payment?
No. Not patient pay. And if there's a past due balance, that's an interesting question. You know, the FTC said it can't be mandated and it can't be considered a resource, and it's considered more of a tax credit, but that still means it's money in the resident's pocket. You know, I don't know the answer to that, but it's not going to impact current patient pay nor current MA eligibility. But it's an interesting question on back pay on an old due balance. That's interesting.
Yeah. So this is the other question that came in on that. If the family or resident wants to pay their stimulus to the facility, can they do so? So
if they have a prior past due debt and they voluntarily want to get square with the facility, I guess that stimulus money is to do whatever they choose with. And they have a right to do what they want with their money.
All right. Let's see. Here's another stimulus. Can we give the stimulus to a family member to help them out?
Well, when we say the nursing home doesn't control the money, but they may, in reality, you know, maybe it's in the person's account. You know, I think you're going to want to get some sort of authorization guidance from the resident, a POA, to say, yeah, divert the stimulus payments to his son because he needs help or something. I wouldn't do that without some sort of guidance from somebody that has decision-making capacity if the resident themselves don't have decision-making capacity. Okay,
more on the stimulus. Would the CAO review at the next MA renewal if 12 months have passed, the recipient received fair market value / compensation if, for example, withdrawals made at one time for $1,200, perhaps giveaway?
Oh my gosh. It's like a law school question. So, I mean, I think that's an interesting question. Will the CAO subsequently treat gifts of stimulus monies from residents to family members as and subject to some sort of transfer penalty? You know, if it was me, I would argue the FTC said it's a tax credit, and the Fed said it doesn't impact patient pay, and they can do with it whatever they want. There would be arguments to be made.
Okay, so some more on the stimulus. Can a facility encourage a resident to use their stimulus for a back balance? We already, sort of talked about this. It says other attorneys have told us yes, just as they can use any money that belongs to them for a back balance. What do you think, John? Is this risky for facilities?
Well, so the words encourage, we heard, and I heard before, voluntarily want to give the money. Okay, that's fine. Do you want to sue somebody for that stimulus money? I mean, you legally may have the right to do so because it's a resource sitting in a person's pocket. They owe you money, so you can bring a lawsuit against them anyway. It may be more of a question of public policy or your internal policy and how much money is on the line and what's the upshot and what's the downside from a perception standpoint. But one would think it'd be a viable cause of action to look into. If somebody owes you money, you can always bring a lawsuit against them. The question is, can you collect on that? And if they have money somewhere, that means you can collect from that money. And so that's really the issue. You could always bring a lawsuit. The question is, can you compel the payments of the stimulus? I don't really see a huge distinction between the stimulus money and any other money at this point. But it might be risky business from a public perception standpoint. But that would be the client's decision.
All right, here's some more on stimulus. and I'm going to just put these, kind of lump these two together because they're kind of together. So is the stimulus money subject to the monthly gifting procedures no more than $500 per month? And then the second point here, let me get down to it, relates to that. It says, but they can't gift the stimulus payment, can they? Or at least not more than $500 a month.
Yeah, I don't know how that's all going to be treated. I would be surprised if we are told by the federal and state governments hands off the stimulus money, and then the resident is not allowed to do with it what they want, and it's going to impact their MA eligibility. I think that would be a problem. I would be surprised if that's the way that played out.
Okay. That's all I see on stimulus at the moment. So let's go back. There's a couple more points here, going back to that email address. If everybody wants to get a piece of paper, and I can send this in the follow-up information as well. The address to send the 180-day claims is RA-provider operation at pa.gov, and said to be two attachments, one with transmittals and claims and one with supporting documents. In subject, put 180-day exception claims and the facility name. So again, I will put that in the follow-up email that I send out after this. Okay, so we have a couple more. Let me see here. That one's related to that. Okay, so another stimulus question. Should stimulus money be held in an account separate from normal PCA? Otherwise, at renewal time, it will appear as an asset for the resident. Is that correct?
Well, again, I think if you're accounting for it and you account that there's stimulus money in there, you can keep that within the same account as long as you can account for it. And then when it's time for a redetermination, the government said that those monies are not considered a resource. I would just be able to, identify what amounts were in there that relate to that.
Okay, let's go down here to another question. Give me a second here. They're pouring in, John. This is good stuff. So here we have RFMS has the following statement regarding the impact of stimulus checks. So this is quite long, so bear with me. According to the latest information, stimulus checks due to COVID-19 will start being distributed in mid-April. Your residents are entitled to keep the full amount of these checks. The amount will not be counted against any asset cap, such as Medicaid, for 1 year. For transferring account types, the RFMS will automatically retain the entire check amount in the resident's account. Let me keep going here. Hold on, I gotta scroll down. You do not need to change the account type to non-transferring.
Okay, well, that seems to mirror the federal and state guidance on the stimulus.
Okay, here we go. Here's a question. What should be done with stimulus payments received for deceased residents?
I would say they have to be returned. I mean, they're deceased, so they probably shouldn't be getting their stimulus payments. But I guess that is, unfortunately, a consequence of something that will be happening. I can look into that to see what the policy would be about returning that money. I don't know if it's designed to drop down to a beneficiary or what have you, or it's going to go into an estate. If there is an estate, it's possible, but maybe it just has to be returned. So I'll make a note of that to try to figure out what do you do What do you do with that for a deceased resident?
So here's a comment. Stimulus checks for deceased persons are actually marked deceased on the check.
Come on. Well, I don't have the answer for that. I will look into it, and we'll try to. Wendy, when you do a follow-up, we could try to get the concrete answer on that.
Absolutely. Okay, that's all the questions we have for now.
Okay, so then going back to we're talking a little bit about the hearings. The Bureau of Hearings and Appeals was only open closed for like 2 or 3 weeks, and everything can be done phone, email, fax. So when you're saying what is going on with the BHA hearings, they're going on, and as you're probably aware, we're getting subpoenas issued, we're getting resolutions, we're getting stips and what have you. Now there was a short period of time where the hearings were canceled because they were closed. I'm hearing mixed results of, my hearing got rescheduled as a matter of due course. I'm still waiting for my hearing to be rescheduled. So anyway, if you're waiting on your hearing to be rescheduled, a recommendation here would be just to correspond with the BHA requesting the canceled hearings be rescheduled. I mean, they have tens of thousands of hearings, so a reminder is not going to hurt. So again, when we talked about documenting attempts to obtain verifications, and either if you're handling the hearing yourself or you have counsel handling the hearing, if you've got all these documents that say I attempted, I've got a flexibility standard, I've got case law on impossibility of performance, I've got regulations that support if someone's cooperating to the best of their ability, there should be eligibility granted. Those are the building blocks of an argument in order for you to establish Medicaid eligibility, particularly in this, crisis mode and pandemic mode that we're in. So I'll give you a little example of what we went through right when this hit. This is an actual case that we had here. So the facility entered into a stip at a BHA hearing on March 11th, agreeing to provide verifications by March 25th. On March 19th, the shutdown was ordered in PA. I believe that's I think I have the right date, but thereabouts. On March 24th, we got involved and we filed a request for an extension of time due to COVID-19 pandemic. The extension of time, we didn't get a response from the BHA. On April 29th, we filed a notification of dispute with supporting legal arguments challenging the stipulation deadlines. The legal arguments are what I've kind of been referencing earlier. On May 15th, the BHA did issue an amended order, extended the deadline by 120 days. So that's really one of the first ones that we saw out there. It's good to hear. You said, look, the deadlines were due. Everything was closed down. I couldn't get anything, so they gave us another 120 days to move forward. Should be able to get them, within that time frame. That's a lot of days for the BHA to grant an extension. So recommendations. Again, document all steps taken during the verification process, and if eventually a stipulation is entered into and the verification still can't be obtained by the deadline, you want to consider filing a notification of dispute. If you're handling it, on your own in-house, smaller matters, read the legalese at the bottom of the BHA order about the notification of dispute. So here's something, and I would be interested to hear from people on the participants, is this level of care denial. I just heard about this yesterday when I was making the rounds with some clients, talking to them about today's webinar. And so what I'm hearing is we have people applying for Medicaid. They're being deemed not medically or clinically eligible because they only have the COVID-19 diagnosis, and maybe they're doing better, they've gotten better, but they can't be discharged. I don't really have nitty-gritty on some of the facts here, but basically the Area Agency on Aging is saying you're not eligible for the level of care, and so we don't even bother with the financial side of things. So since the resident's not clinically eligible, you can't even get to the stage of determining financial eligibility. I reached out to some counsel for DHS, and they're kind of putting me to another area, which is fine. And I reached out to try to find out from the Area Agency on Aging what is going on here. I mean, if we've got people that have to be in the nursing home because of a COVID-19 diagnosis, but they don't have other very serious situation or problems that raise to the skilled level of care, and we're not gotten paid for that. That I don't really think that's the policy that the state, I hope, would want to be implementing. So my recommendation is to appeal that clinical level of care denial. And I think I just can't imagine that the state would want to have this as a policy. But in the interim, if it's there, I would file an appeal from that. And I'm sorry, I don't have a lot of information on that. If anybody has anything to add in the audience there, please do so through the chat through Wendy. But I think appeal it. But I think that's something perhaps the trade associations and PHCA may be able to look into and talk to their folks about. I mean, they're obviously very involved with all the advocacy on the funding and numerous issues and that are impacting you guys. So maybe we'll add this to their list. All right.
So we do have some comments here.
Okay.
Questions. Most COVID-19 individuals are eligible for Part A coverage.
Okay. That would be a very good resolution.
And then who do you appeal the clinical level of care denial to?
Don't know. Haven't done it. And I've been practicing in this area of the law since 1994. We just don't have level of care denials that reach the lawyers. But I think, generally, if we would look at any Pennsylvania code provisions, when there's an adverse action by a government agency, there's general provisions where you can file appeals. I wouldn't be worried about finding some way to get it brought to a head.
Okay, here's another. We have filed application for financial and received denial from CAO for level of care. Then we appeal the denial from CAO regarding the level of care. And then it says you can't appeal the level of care of appeal without submitting the MA application. The information is at the bottom of the LOC denial.
So that's interesting. So the CAO is issuing the denial on the level of care, not coming directly from either the PCA or the Area Agency on Aging. Yeah, I'm sorry I don't have a lot of answers on that issue. I just know, it is an issue, and I think it'd be a major problem, and it needs to be resolved, probably at more of a global level. And that's kind of ridiculous for a denial on that. We've covered stimulus quite a bit, so we'll go to the next one. Well, this is just kind of a one-off. If you go to the next one, I've been trying to go to other medical expense. I've been trying to get a resolution or opinion on this. What I'm hearing from some clients, and this is a non-COVID issue, but the MCOs appear to be disallowing a prior nursing home debt incurred prior to becoming MA eligible as a permissible other medical expense, which, if you have another medical expense, you offset it against the current patient pay, and you get paid that differential. So I didn't see any changes to the ops memo when they went to CHC, and I'm still working on trying to get a resolution of this with DHS counsel and or the MCOs. So that's just kind of a one-off issue, not really COVID, but I know it's starting to impact some providers. So I'm done with the Medicaid side of things. It's 2:51. Rodney is, oh, sorry, Rod, you have a whole whopping 9 minutes to go over half of the presentation. So I'll turn it over to you, and then, I'll stay after the hour to field questions or what anybody, Wendy, whatever you recommend.
Okay, let's go over these questions that relate to this portion, and then they'll be out of the way, and then we'll get into, and I'm sure this is good stuff. We're only approved for one CEU on this, but I think it's such good information that everybody's gonna hang on tight here just to hear what's happening. So let's just get through these last couple comments and questions, and then we'll go to Rodney. So it says, hard to imagine a nursing home resident with the only diagnosis being COVID-19, and LOCD from the AAA does not even include a diagnosis. And then here's one. I had a CAO deny LTC due to LOC. However, we had them changed and approved LTC due to the doctor approving the LOC on the MA51. AAA is the one denying the LOC, but you can't appeal through that agency. It has to be done through DPW, which I guess is really DHS. I have completed one appeal on this issue prior to COVID. I had a BHA hearing, and they interviewed the AAA and requested medical records from the facility.
Okay, so it sounds as if you get the AAA is the one that denies it, but it comes through the CAO as if it's a financial denial, and then you're up through the Bureau of Hearings and Appeals through the administrative appeal process. That's good. That's all set up there. So, I mean, it's not good that there's a denial, but it looks like that would be the process to follow. But again, I've never even seen one.
Okay, the last one here is if they say they are not NFCI, you have to send it in with the app. Then when they deny them for not being NFCE, you appeal the LOC with the CAO, not the AAA.
Okay.
All right. Okay.
A lot of an acronym, but I think I understood most of those initials. I think so.
Yeah. All right, Rodney, we're turning it over to you.
Thank you, Wendy. I'm just going to go through this and do a little bit of a summary of what I have prepared. And it is helping you understand where we're at right now as far as the Pennsylvania courts and their status of being open, and in particular, how guardianships are affected. The Pennsylvania Supreme Court issued an order back on March 16th, and at that point just declared a statewide judicial emergency. Then following up on March 18th, the court clarified the terms of that closing, and the court stated that the courts throughout the state would be closed generally through at least April 3rd. And I'm going to go through this, and you'll see that that's obviously been extended a few times. The time calculations and deadlines for filings were also suspended through April 3rd. And the court first used a term which has been used throughout the many orders that it's issued. That phrase is advanced communication technologies, which in most circumstances is going to be video conferencing that the court would use instead of having the parties and the attorneys attend the hearings in person at the courthouses. The court also encouraged the local county courts to make decisions on matters on what's called on the papers, which would mean that rather than having a hearing to take argument, the court would decide the legal issues based on the statements in written documents that the parties have filed. The court also first used the phrase essential functions, and that has an effect on how the court closings apply. The essential functions have continued to be that the court should process them as much as possible. And as you would imagine, those essential functions are matters that cannot wait. And in particular to our practice and to your facilities, emergency guardianships have never stopped throughout this process. They have been held, however, by phone or by video conference, and I think the court prefers to have video conference so it can see the parties and see the people who are testifying. The Pennsylvania Supreme Court also suspended dispossessions of residences, meaning that parties could not force the eviction or ejectment of people who were residing in residences. And during that time, under that March 18th order, that was through April 3rd. The Pennsylvania Supreme Court issued about 10 orders, and 3 or 4 of them have been extensions of that March 18th order. The court also, in a March 24th order, added to the essential functions the filing of precipices for writ of execution. And this was important because of statutes of limitation. The parties needed a means of filing an action to prevent their cause of action from being barred by the statute of limitations. So the court allowed filings of writs of summons, which are one-page documents usually that just say we're planning on filing a complaint later. And by filing that can protect a cause of action from being lost because of the statute of limitations. On April 1st, the Pennsylvania Supreme Court issued its next update of these, extending these suspensions that were given in its March 18th order. And at that time, most of those suspensions and extensions were extended again through April 30th. The Pennsylvania Supreme Court has given the County Court of Common Pleas president judges much discretion to decide how it is best to run their courts based on the situations that they're dealing in each of those counties. And that discretion continues. The April 1st order extended the timelines for time calculations and deadlines for filings to April 30th. And the court did say at that time that it clarified that it expected that non-essential matters could continue to move forward within the sound discretion of each county's president judge. However, that the Pennsylvania Supreme Court encouraged the president judges to create procedures that would protect the health of the participants, and in particular by using advanced communication technologies instead of in-person hearings. And again, that the prohibition on dispositions of people from residences was extended again to April 30th. April 28th was the date that the Pennsylvania Supreme Court issued the most recent order, which states the extensions of all these matters. The court stated in that order from April 28th that beginning May 4th, unless otherwise provided by the local courts, Pennsylvania courts should be generally open to conduct all court business. In the next sentence, they clarified, though, that all in-person access and proceedings shall be strictly limited according to the terms of this order. And so what that means is, at least from the Pennsylvania Supreme Court's standpoint, from May 4th forward, courts were not closed. However, the court did go on to say that local president judges could extend through May 1st or June 1st their extensions, and even past June 1st with supportive reasoning. The court, after using essential functions in all the orders up to that, broadened the term to refer to critical functions. But in the April 28th order, the critical functions are very similar to the essential functions. Again, the court encourages decisions of matters on the papers and by advanced communication technology. And the disposition of property has been permitted since 2011. So there's no longer a prohibition on disposition since May 11th, unless local courts have prohibited that. So at this point, from a statewide level, there are not limitations on proceeding with courts. For the time being, we expect that courts, even once they are fully operating, will likely hold hearings by video conference as much as possible. It is possible that courts will require that attorneys attend the hearing at the courthouse, but that the parties will not be required. So let's look a little at most relevant to your facilities and the work that we do for them. Let's look at how these will affect permanent guardianships. When the court shutdown first began, courts postponed holding permanent guardianships hearings and stated they would later reschedule the hearings. That was the status quo through April 2020. Permanent guardianship hearings have not been held since the shutdown began in March. Within the last few weeks, we've seen that courts have begun to reschedule guardianship hearings. I expect within the next 2 weeks, it is very likely that the courts will reschedule many permanent guardianship hearings and more promptly schedule hearings as we file new petitions. I expect that, and I think all of our attorneys do, that it will be most likely that those hearings will be limited and somewhat different than the normal permanent guardianship hearings we do, in that it's unlikely that your facility's staff or the doctor will be required to attend the hearings in person. It's possible our attorneys will be required to attend, but your facility staff, it is most likely, will be permitted to testify by video conference. As I mentioned before, emergency guardianships have been, as part of essential functions and then later critical functions, have continued to be conducted by courts as necessary. That has not changed throughout the whole process, and the local courts have and will hold emergency guardianships hearings by video conference, possibly requiring the attorneys to attend. So that covers the status of where we're at now with how the courts are operating. They are open, and we should be seeing a lot more movement in the scheduling of hearings. As our attorneys obtain the scheduling of those hearings, we'll work with your staff to prepare them to participate in the means that the court has permitted them to participate.
So thanks, Rod. Thanks for getting through that quickly. I know there's a lot of material. Good summary. I was doing some internet research, and the initial findings of my internet research are that the stimulus checks are supposed to be returned to the IRS. We'll get a little bit more than my 3-minute Google search information, and we'll get you guys a response on that issue. The emergency guardianship, that was interesting. I mean, I think the courts really are bending over backwards to make things happen. We were in a court in an area where there's a lot of COVID-19 residents, and we had an issue come in with regards to one of the residents that was likely COVID-19 at around 11 a.m. on a Friday morning. 5:30 that night on a Friday, the judge, court stenographer, medical director, nursing home administrator, social worker, proposed guardian, all on a Zoom call and addressing the emergency guardianship need that had arisen. So, I get kudos for them to make it happen. And he wasn't even a guardianship judge; he was the emergency judge. So, good for them. So that's open, and people are trying to do what they can do. So here's our summary recommendations. So back to the MA redeterminations, respond to the request if possible, otherwise apprise the CAO why you cannot. Still file your MA applications if the resident family member cannot. There's been no change on the retroactivity provisions based on COVID. Utilize the new flexibility standard at hearing or in your discussions with the CAO. That could be to your benefit. I hope it is. Consider filing your appeal within 30 days, even though you have 90 days. Move the process along. And as I said repeatedly, make attempts to obtain verifications and document those attempts. And we have just one more slide there. If you had a canceled hearing, reach out to the BHA to get it rescheduled. Again, document all steps taken during the verification process. And eventually, if you're in a stiff and you still can't get the verifications, read the little legalese at the bottom of the order and consider filing a notification of dispute. That's something our office, is always acting from our standpoint from a timing. And appeal the clinical level of care denial. Some of you on the phone had experience with that. I appreciate your input. Didn't have any particular experience with that. I was a little troubled by the fact that it was happening. So that is all I have. We are slightly over our time. I will hang out. Rodney will hang out and answer any questions if there's anything further coming around, Wendy.
Great. Yes, we have some questions coming in. So, how backlogged do you expect the courts to be once they reopen to hear cases like permanent guardianship? Monroe County courts don't open until May 31st, so I'm sure that's differing throughout the state. Throughout the state and each county, when they're reopening and how quickly they're going to get through everything.
Yeah, I think that's interesting. I mean, we have one attorney here in our Harrisburg office who has a dozen hearings in June. And Rodney's out in Montgomery County. They might be, phased out a little bit later. And then we have attorneys out in the western part of the state that are getting phased out earlier, and it might be spread out. I think they'll get it done. The courts are scheduling hearings. They know it needs to be done. They've already put them off, for a month or two if it's been sitting idle and there's been no healthcare issues to drive an emergency guardianship. So I think it will be crowded and there'll be a lot of work to be done, but I think it'll be done expeditiously.
Great. And then there was a question for those of you who aren't regularly on our webinars. I will be sending an email out after the webinar with the copy of the slides. So yes, those will be made available after the fact. Here we have a question or comment. Let's see. Will there be any protections for nursing facilities from lawsuits related to COVID death or injury? We have had 28 deaths at our facility, and I would expect some backlash eventually.
Yeah, so that would be the subject matter of probably a whole 2-hour webinar, and would be related to, the attorneys that are highly specialized in malpractice and what have you. But from a statutory, from a legislative standpoint, PHCA, as well as the other trade associations, has been pushing for civil immunity to be extended to long-term care providers and healthcare providers and hospitals. There was a directive that extended civil immunity, but which is good. The civil immunity was only to the staffers, the workers, the nurses, the doctors. All that's good, but the plaintiff's attorneys are going after the facilities, and they have the insurance, and that's what they're going over. I mean, when this whole thing kind of faded out of Italy, there was an article about Italy's next pandemic lawsuits. So PHCA and other trade associations, along with PHCA, taking the lead on, getting funding bills, pushing them to get funding bills passed. I mean, they're really pushing on civil immunity as well for the providers, and I hope it happens.
All right, here's another one. Did you say that we have 90 days instead of 30 to file an appeal?
Correct. Yes.
All right, well, we're going to try to wrap this up. So I want to thank Rodney and John for their time today and for this great information. Again, I thought it was great with lots of questions and comments. Hopefully we can, do more of these. I think they're really helpful. And, look for PHCA is trying to come up with, other COVID-related webinars and sessions for in-person training once that comes back into play someday. So please don't hesitate to reach out to us at the association. We have staff who is, there and working diligently to help you guys through this crisis. And, they're there for you. And anything you have for me, as far as education that you want to see now or later, just please don't hesitate to reach out. We want to get the information timely to you and help you as much as we can. So if there are any other questions, please type them in now. We'll just take another minute or two. We'll just take one or two more questions before we sign off. So there is a question here. Is an NHA covered under civil immunity?
So I'd have to reread that Wolf's directive, but it's my understanding that the directive applies to individuals working at healthcare facilities as opposed to providers. So, I'm assuming that would cover nursing home administrators as well. You want to double check that though, and confirm that with your insurance company or what have you if you're concerned about that, but that's my understanding.
Okay, all right, we're going to wrap this up. I see no other questions. If you have questions, I will be providing John and Rodney's contact information, so you can feel free to get in touch with them, as you think of things, over the next couple days, weeks, months. I'm sure there's going to be a lot of questions coming into play here as we all try to figure this out. So don't forget, I'm going to be sending out a survey probably tomorrow. Look for it tomorrow. Please, use that to give us some feedback. I think it was terrific, and I really appreciate John and Rodney presenting on this topic today. And don't forget to just keep an eye out for more webinars coming your way from us on COVID-19 related. We're working on one for the next week or two about reporting, and there's others that we're looking into scheduling. So just keep an eye on the daily communications as well as our website. And don't hesitate, like I said, to be in touch with any topics that you would like us to see presented, and we'll make it happen. So again, I want to thank everybody out there. You guys are on the front lines. You're doing amazing work. We appreciate it. You guys are the rock stars in all of this. You're taking great care of your residents, keeping them healthy and happy when you can. And just the things I see outside the box are just blowing my mind. The things that you are coming up with are mind-boggling. So keep up the good work and hang in there. We're here to support you. Have a great rest of your day. And again, hang in there, everybody. Thanks for participating today.
Thanks, Wendy. Thanks all.